It is important to understand Guyana's extradition law, what was, what changed, and why it matters. The recent indictments of high-profile Guyanese businessmen have reignited public interest in Guyana's extradition laws, legislation that governs how citizens and foreign nationals accused of crimes can be surrendered to other countries for prosecution. For years, Guyana's extradition process was viewed as slow, outdated, and riddled with loopholes. But major reforms passed in 2024 have reshaped how the system works, aligning it more closely with international standards and deepening cooperation with countries like the United States. Now, what was there before? The old Fugitive Offenders Act. Before 2024, Guyana operated under the Fugitive Offenders Act, Chapter 10, Paragraph 4, a law originally based on colonial era British frameworks. Under that version, extradition requests had to go through lengthy judicial hearings with strict evidentiary requirements. Only original evidence or sworn witness statements were admissible in extradition hearings. The Minister of Home Affairs had broad discretion to approve or block extradition, sometimes delaying cases for months or years. Appeals and legal challenges could stall proceedings indefinitely, allowing accused persons to remain in Guyana even when strong evidence existed abroad. While it upheld sovereignty and due process, critics argue the system favored delay over justice, a weakness that international partners quietly press Guyana to fix. Now, what has changed? The 2024 amendment. In July 2024, Guyana's National Assembly passed the Fugitive Offenders Act 2024, ushering long-awaited modernization. The changes focus on efficiency, admissibility, and international cooperations. Now, here are the key updates, which includes expanded admissibility of evidence. What that means, courts can now accept a record of the case from the requesting country, including digital documents, sworn affidavits, and official certifications. Evidence no longer has to meet Guyana's full evidentiary standards if it is authenticated under foreign law. This allows cooperation with US and European prosecutors to rely on standardized case files. Streamlined court procedures. What that means? The amendment gives magistrates clearer timelines for committal hearings, limiting unnecessary adjournments. The process now mirrors the Mutual Legal Assistance Treaty (MLAT) standards used by international law enforcement bodies. Ministerial oversight with accountability. Now, the Minister of Home Affairs still makes the final decision, but must now provide written justification for any refusal. This ensures transparency and prevents arbitrary blocking of extradition cases. Closer alignment with the US and Commonwealth partners. The amendments complement Guyana's bilateral cooperation agreements with the United States, Canada, and the United Kingdom. This framework allows for faster information sharing and extradition of fugitives involved in transnational crimes such as money laundering, drug trafficking, and fraud. Now, Guyanese, why it matters in a modern law in a modern Guyana. These reforms signal a clear message. Guyana wants to be seen as a rule of law partner, not a safe haven for fugitives or financial crime. In a region increasingly under US security focus, especially with rising cases involving gold smuggling, money laundering, and narcotics trafficking, Guyana's new legal posture strengthens its reputation as a cooperative and responsible state. However, critics warn that faster extradition also brings new pressures. Now, can the system safeguard citizens from politically motivated charges abroad? Will high-profile cases like those involving politically connected individuals be treated equally? And can local courts handle the complexity of cross-border evidence without compromising fairness? Extradition reform must protect both justice and sovereignty, says legal analyst Anand Prasad. We must ensure we're not simply trading one imbalance for another. Connecting to the present moment, the timing of the amendment coming just before major international indictments involving Guyanese gold exporters raised questions of motive. Yet officials maintain the law's update was part of a broader criminal justice modernization plan, not a reaction to any single case. Still, the new framework could determine how swiftly or whether prominent figures like Nasser and Azruddin Mohammed face extradition to the United States. And in conclusion, balancing justice and sovereignty, Guyana's updated extradition law represents a crucial evolution from a colonial handover to a modern legal mechanism. But the real test lies in its application, whether justice will be pursued without fear of favor, and whether political power will respect the rule of law. For citizens, the message is simple. Guyana is no longer legally isolated. What happens abroad can reach our courts, and what happens here may echo across borders. Follow News Guyana 24 for updates on extradition cases, legal reforms, and the intersection between governance and justice in Guyana. This is Dunstan Wilson. Thank you for listening.